All right, so you've decided that you are going to attempt this process. You're going to go ahead and get your driver's license back by having a hearing with the Secretary of State. The big question is how? Let's take that next step of answering how you're actually going to do this by going and getting your driving record. Now, the easiest way to do this is to do it online. cyberdriveillinois.com, and they're going to let you get your license online if you have a current copy of your license. You see, you have to put in this information into this online form, and one of the things it asks is for some identification numbers off of your current license. Well, if you're here watching this video, I'm going to guess that you don't currently have a driver's license. And so then that eliminates your option. You cannot get it online then here. So your only solution is to walk into any DMV location and get it yourself. Now you have to wait in line and, pay the money and all those things, but you can go get your own driving record. Obviously have to bring your ID or some sort of identification, and then you can purchase your own driving record at the DMV. Now, what they call this is an abstract. It's a history of your driving record. There are two versions of it. One of them is the court purposes abstract, and that's the one you want. There's another one that's called public abstract that has less information on it. That's not what you need. You need the court purposes driving abstract. At this time, I think it costs $12, and you can go ahead and get that at the DMV. Now, the other option is myself and so many other attorneys will get that for you. You can't have an attorney get that for you and analyze all this here. But you've chosen to do it yourself, and so I want to walk you through not only how to get it, but now what are the next steps? How do we actually read this? Because it can be pretty difficult. It's kind of like another language. So I'm going to do my best to walk you through it right now. All right, so once you've got a copy of your court purposes driving abstract here in Illinois, the next thing you want to do is decipher it. Now, you can absolutely ask somebody there at the Secretary of State. They may help you. I've seen that before, but don't rely on just that. This is not that difficult for you to walk through, and it's really important for you to understand it in the first place. So sure, get the help from them, but let's read it ourselves as well. And the first thing you're going to look for is on the right-hand column, there's a column called Stop in Effect. And there are yeses. There might be yeses on some individual lines. So that means that yes, a stop is in effect. In other words, this is one of the reasons that you don't have a license. There could be one yes. There could be 10 yeses. Depends how many reasons you don't have a license for. It depends how many stops there are. And the idea here is you have to clear every single stop before you can have a license. It's the way it works. So let's figure out what those stops are. At this point in time, you can just ignore anything that doesn't have a yes. So let's go to the first one here. We can see a yes. Stop is in effect on this line, and then let's go read why. There's a suspension in effect, and that went into effect in August 29 of 2013, and it's because this person is required to have SR22 insurance. Okay, now we know, right? They need to get SR22 insurance, and then that will remove that stop. And so this is a really important distinction. And you want to clear all the yeses that you can before you go into the hearing. You want the last thing to be your yes for the revocation. Everything else gets cleared up ahead of time. So really important part there. So this person should get SR22 insurance either right before the hearing or indicate at the hearing that they will get SR22 insurance, and that will simply clear that yes. And you're going to find a number of things like that. There can be traffic tickets that are unpaid, failing to appear in court, these SR22 ones, uninsured accidents. Those can all be reasons that you don't have a license and need to be cleared up. But what we're really talking about here is revocations, meaning your license is gone and it's not coming back until you have this successful hearing. And the far and away, the most common reason that someone is revoked is because they have a DUI conviction or multiple DUI convictions. And that is the case here as well. So we're going to keep looking through some of these yeses, until we find one that indicates that there's a DUI. So here we go. We're going to see right here on the screen that there is a yes for a revocation that went into effect on November 13 of 2013, and then they were eligible. The eligibility date is the very next thing. About a year later, they became eligible for a hearing. And that is for operating a motor vehicle while under the influence. That is the revocation, and that is the thing that needs to be cleared at the hearing. So let's now dig in and find out more about this DUI. We can see that the line right above is a DUI conviction. You can see that right here. So it gives us the arrest date. It gives us the disposition date. In other words, when the case was closed out and resulted in a conviction. Now, one thing that's really helpful here is this 501A1, A2, A3. So 501 is a good indicator. That's the actual statute that indicates that it's a DUI. So what we're looking at here is a DUI from 2008, and it gives you the ticket number. Now, I've redacted it here, but it gives you a ticket number, tells you where it was at. It was in DuPage County, and it tells you, yes, in fact, they did get a DUI conviction. So there's one strike, an alcohol or drug-related offense resulting in a DUI conviction. So that's one. All right, here's another. We can see that there is a conviction from 2014. That disposition was entered a few months later. And again, you can see it's 501. So that tells us it's a DUI. This time it's in Cook County, the 2nd District of Cook County. We have a ticket number, and it tells us that, yes, there was, in fact, a DUI conviction. So this person now has 2 DUI convictions. And we're just going to keep going through all these, clearing all the yeses in any way we can, except for those DUI convictions. The only way to clear those is to have the hearing. I hope that makes sense. There's a million different things that could be on the abstract, but what you really want to look for are the yeses, and specifically the yeses that have an 01 in the left column, because that indicates that there is a revocation. So now we figured it out, right? We've cleared a bunch of yeses. We see the last remaining yeses on here are for DUI convictions. It's the most common. It can also be things like aggravated fleeing and eluding. There can be a number of reasons someone is revoked. Most common is a DUI conviction. But right now we want to figure out, can we have an informal hearing or must we have the formal hearing? So just add them up. Add them up. See why you're revoked. If it is just one DUI or 0, it's a different reason, then you can probably have an informal hearing. If it's 2 or more alcohol-related offenses, then it's always going to be a formal hearing. So that's your decision to make. Formal is like it sounds, much more formal, much more work than an informal hearing, but this should be a really good indicator. You should have a high degree of confidence as to whether or not you may do a formal or an informal hearing after adding up the DUI yeses on your abstract. Now that you know if you need a formal and informal hearing, you might be tempted to run out and go have that hearing, right? I know you want your license soon. You're tempted to go have that hearing, but I want to caution you to slow down and do this the right way. When you're represented by an attorney, we're going to take this in a very specific process, and I'm asking you to do the same. The next thing you want to look into is how to get a drug and alcohol evaluation. I know you probably did this years ago when you had a DUI or whatever the case may be, but you need an updated drug and alcohol evaluation. And that date of the evaluation must be within 6 months of your hearing. So don't rush out and go get that, request that hearing. You need a drug and alcohol evaluation first. The timing here is very important. So there's a number of drug and alcohol evaluators out there. They have to be DASA, D-A-S-A approved. Most are for the Secretary of State to accept it. But I will tell you, there are some really good evaluators and some really not so good ones. And you are only as good as the paper that you're walking into that hearing with. So I have seen, unfortunately, evaluations that are just terrible. They're a sentence long. Secretary of State's never going to approve somebody with that. It's just you need to do a good job, a good evaluator who writes a good report and evaluation on you, and that's what you want to walk into the hearing with. So we have our list of ones that we recommend, and we will only do hearings if our clients have gone to these specific evaluators because we know they do a great job. So you're going to have to find that. We've published a list. The Secretary of State has a list of evaluators that they accept, and you're going to have to go through, contact them. Now, this is sort of the part where you're off on your own. Your attorney, if we were representing you, would put you in contact with our evaluator, and then you go do that. The attorney's removed from that portion of it, and that's because, the evaluator's going to get into everything. They're going to get into your entire history, when you first consume drugs or alcohol, your pattern of consuming them, the frequency with which you consume, the amount with which you consumed all throughout the years, and that plays into your evaluation. So there are 4 classification levels in these evaluations. Your evaluation will give you one of the 4 levels. It's a little tough because your circumstances, the circumstances that got you here, are going to also help determine what level of risk you are. You see, you could nail the interview. You could have the best interview in the world, but still your history may haunt you and cause you to have a higher level of risk than maybe you otherwise would. So what I'm saying here is the lowest level is minimum risk, and the only way you can get that minimum level is if you only have 1 DUI. If you have 2, then you're already above minimal level. Also, your breathalyzer on that prior DUI really matters. If you blew twice the legal limit of 0.16, even with 1 DUI, you're not going to be minimal risk. See, that's what I mean by those circumstances. Your history sort of haunts you and helps determine what your risk level is. But minimal risk is the least. The next one is moderate risk. That's for 1 or 2 DUIs typically. Again, depends on your breathalyzer, but it is what it is. The third is significant risk. And then the 4th and highest is high risk. And you can be either high risk dependent or high risk non-dependent, meaning an alcoholic. That mean dependent. But you can also be high risk and not an alcoholic, not dependent upon alcohol or drugs. So you're not going to be able to influence your results of the evaluation all that much. An evaluator has some pretty strict criteria to go by, like I said. But obviously you want to be prepared and thoughtful, and you want to have a great evaluation. And your attorney can often, if you had an attorney, they can often talk you through that. All right, so the reason that your evaluation classification matters is because it determines exactly what you need to bring into the Secretary of State. Think of it like this. You have this evaluation, and then you go to the Secretary of State, and you say, hey, I want my license back. If you are minimal risk, you're going to have to, you have less to prove, right? You need minimal things in order to get that license back. If you are high risk, you're going to need more. And that typically comes in the form of documentation, of proof that you have changed and that you are not at risk again of getting a DUI. So let's just kind of compare. Minimal risk is you're going to have to show them that you completed 10 hours of risk education. 10 hours, not too bad. But as soon as you jump up to even just one level above that, moderate risk, now you've got 10 hours plus another 12. So you've got 22 hours. You get up to significant risk, you've got 20 hours plus 6 months of aftercare. So there's a whole bunch of different levels. It's just kind of stair-stepping up with each classification level means more documentation that is needed. So if you are high-risk dependent, it's the highest risk level, so of course it's going to require the most documentation. What it's going to first require is proof of abstinence, proof that you no longer consume. any drugs or alcohol. And that proof that it's been over a year since you have consumed any drugs or alcohol. You need 3 different types of proof of that. You need 3 different letters from people stating that it has been more than a year since you've consumed any drugs or alcohol. That's 3 letters of abstinence. The next one is letters from your support program. Typically, that's AA, Alcoholics Anonymous, or NA, Narcotics Anonymous. That's the most common program. There can be some others. However, I will tell you that the Secretary of State definitely favors AA and NA over any other, third-party, any third-party support programs. You're going to need a letter from your AA sponsor. It's not hard to get, especially if you've actually been in AA. And then you may need, if you have that non-traditional support, you're going to need at least 3 letters from them. So a church group or something like that that's not AA, but another support group, you're going to need letters from them. So that's a big lift. You need these character letters that are really recent too. It can't be like old. It has to be within 45 days of the hearing. So there's a lot of things that need to line up in order to do that, and that's required if you are going to be at that highest level, high risk dependent. All right, so now you've got your abstract. You've read your abstract. You've figured out if you need a formal or an informal hearing, and you've even gone to an evaluator, paid for and completed an evaluation. That evaluation then determined what you needed to do, how many hours of proof that you needed to do in terms of risk education and treatment. You've done that, right? Now, a lot of times your old risk education that you did during the DUI can serve as this, or there can be a waiver that's filled out by the evaluator, but maybe not. Depending on your history and what documentation you have, you may need to complete hours now, more recently, complete these risk education and treatment hours prior to proceeding to the hearing. I can't really tell you that. Your evaluator is going to walk you through all that. A good evaluator is going to know exactly what you need and make sure that you have completed everything that is required before turning you back over to your attorney or turning you back over where you now can go have that hearing. So let's pause for a minute and pretend that you've got all that done, right? You've now completed everything. You've got your documentation. You've got your evaluation in hand. It is time for you to request a hearing. Now, if you are fortunate enough to be having an informal hearing, then you can just go to the DMV and have the hearing. It's not by appointment. It is on a walk-in basis. You can look at the Secretary of State. There are dozens and dozens of DMV locations that will allow you to have an informal hearing right then and there. So you bring your documentation, you go to that hearing, and you and the hearing officer sit down and have that hearing. Now, in a later video, I'm going to walk you through what to expect in that hearing, but pretty simple. Like, that is a massive advantage, by being able to have an informal hearing. On the other hand, if you are required to have a formal hearing, and in my experience, most people are, if you have to have a formal hearing, well, then you need to request that through the Secretary of State. There's a form that you fill out. You're going to mail them $50. That's the cost of requesting the hearing. And they will reply back some weeks later with your hearing date. It will be at a specific date and time and location. And there are only 4 locations in the entire state of Illinois that do formal hearings. And those are Chicago, Joliet, Springfield, Illinois, and Mount Vernon, which is way down south. I'm in the Chicagoland area, so I'm very familiar with Chicago and Joliet as well. So it will be at one of those 4 locations. You can request which one you want to do it at. It will give you a date and time, maybe 6 weeks away. It depends on how backed up they are. 4 weeks, 6 weeks, 8 weeks away is when your hearing will be. They will give you a specific date, time, and location. And so now you have to prep. You have to get and make sure not only is your evaluation ready, your documentation is ready, and that you now, especially if you have a formal hearing, you are prepared for the questions that will come in that hearing. Because if your evaluation says one thing and you answer differently in that hearing, you're going to get denied. It's very, very easy for them to deny you. And being inconsistent or not knowing answers at the hearing is definitely a basis and the most common reason that people get denied. So next, we're going to talk about the relief that you're going to be requesting, and we're going to prep you for that hearing. So when you fill out that form requesting a formal hearing, you have to select the relief that you're seeking. What we do is we check all the boxes. You are seeking a full reinstatement of your driver's license if you're eligible. Who doesn't want that, right? That's the ultimate goal, is to get a full reinstatement of your driver's license with no restrictions. But more commonly, people are granted an RDP, a restricted driving permit. So you absolutely should be requesting a full reinstatement, and in the alternative, if they're not going to give you that, then a restricted driving permit, because a restricted driving permit is a great path to eventually getting that full license. So how does this RDP work? Well, first of all, you need to show to the Secretary of State that you have a hardship. Essentially that, things are more difficult and if without the license, right? And if they were to grant you this restricted driving permit, then it would eliminate or reduce that hardship. So the most common one by far is employment. And it's not just like I have to take an Uber and that stinks, right? You have to go further than that. Right? You have to show that it is causing a financial burden on your family. You have to show that if you were to have a full license, you could have a better job or go work at a different job, that would provide you and your family, better pay, better benefits, whatever the case may be. You have to show a real hardship, because everyone has some sort of hardship. That's obvious, right? Not having a license is difficult, but you have to show something very substantive, something very tangible in terms of, missed opportunities. And that's the most common one, is employment. It can also be medical, right? You or a family member that you live with has medical issues and regular appointments, and it is a hardship on you and the family by not being able to take them or take yourself to that medical appointment. Education's another one, just like employment, right? If you're in school, you have to get to school somehow. It can also be for immediate family members as well. Taking your kids to school is one I see often. And that's a basis for a hardship. And finally, there's AA meetings. So if you go to AA meetings or support program, well, if they're in person and you can't drive, then it's reasonable to think that you're missing out on AA meetings, right? And so that's kind of counterintuitive to this whole process, right? So that is another basis. I don't see that one quite as often. You have to be sort of high risk in the first place in order to, be attending those AA meetings, or commonly you're high risk attending those AA meetings, and you're putting forth the argument to the Secretary of State that if you had a permit or a full license, you would be attending those AA meetings on a more regular basis. So those are your common, those are the types of the bases for relief. Those are the hardships that you can request. And then in response to that, they can deny you outright. They can simply say no. They can give you a full reinstatement if you're eligible, or they can commonly give you a restricted driving permit that will allow you to drive only during specified dates and times and locations for one or more of those reasons that we mentioned.